when dealing with the directives, it's, as I've mentioned, important to realise that they are not codes as such. They're not a comprehensive procurement code, and neither the directives nor the UK regulations can really be seen as such. And the reason for that is quite simple. We are not obviously the only member state in the European Union, and many other member states have a long history of procurement law. France, for example, they have decades of procurement law, well-established national legislation. And what the directives were originally about was simply harmonising, where necessary, the existing national measures, to try and bring them together so that the differences between those measures did not create obstacles to trade between member states in public sector purchasing. The deception, as it were, perhaps that's the wrong word, the problem from a UK perspective is that because we had a blank page, you start from a blank page and suddenly you get produced these directives and regulations, you suddenly think, well, that's the law, that must be what I have to comply with. And that, as I say, is to miss the point. These directives were never intended to be a comprehensive code. You do have to sort of fill in the gaps and bear in mind that, in fact, they don't cover the whole territory. The directives indeed exclude a number of different kinds of contract altogether. There are other kinds of contracts, such as Part B service contracts, which is a technical terminology for certain categories of service, such as, for example, some education services, a large range, legal services, a large range of services are Part B service contracts, and they are subject to a reduced set of obligations under the directives. But even those contracts which are excluded from the directives, it is now clear from the case law of the European Court of Justice, are subject to the primary law that I referred to on the previous slide. So you have the odd situation that if you read the directives, you'd think, for example, that contracts, construction contracts below the relevant thresholds of about £3 million, you'd think that those contracts were not subject to any obligation, but you'd be wrong, because the treaty, we now know, has some effect below on contracts even below those thresholds, although quite what the content of those obligations is a matter of debate in the case law. It certainly doesn't make it any easier that it's these small contracts which are actually one of the current real minefields in EU procurement law. So you have an aspect where at one level the directives may be narrower than primary law, in the sense that the primary law covers a number of things which the directives don't. There's also circumstances where the primary law may not apply at all. You may be dealing with private utilities which might not normally be subject to the direct effect of some of the provisions of primary law, depending on a number of technical questions. But the directives, the utilities directive in particular, means that procurement law does apply expressly to them. So you have a double confusion, as I put in the bubble at the bottom. The directives may be both broader in some respects and narrower in other respects than the EU primary law. So just simply trying to work out in any given case what is the relevant law to this particular type of procurement is not straightforward.